Good morning, everyone. Let me go live on Instagram. Good morning. Good morning, everyone. I'm just going to wait for you guys to tune in. Welcome in. Come on in. I'm going to be looking left and right for both screens. Good morning. If this is your first time joining, welcome. Let me know where you're tuning in from. Good morning, Sexy Sure. Good morning. Good morning, YouTube. Good morning, Facebook. Good morning, Instagram. Jay Achimore. Good morning. Good morning, Shauna. Thank you so much. Chef Pascal, too. Good morning. Shawnee from New York. Good morning. I just got back from New York on Sunday as well. So it's good to be in New York. Good morning, Winning Six Boss. Good morning, Conscious from Chicago. Welcome, everyone. Let me introduce myself. My name is Aisha Chidole. I'm an immigration attorney, and I represent clients all over the United States with their immigration matters. If you would like to schedule a consultation, please call our office, 407-995-6567 or 678-325-1037. You can also send a WhatsApp message to 404-333-8751. We don't usually take calls on our WhatsApp number, but you can always leave your message there, and we can schedule you for a consult through there as well. So cases we handle family-based immigration cases, so marriage, family, siblings, parents, fiance visas. We also handle humanitarian cases like VAWA cases, which is based on domestic abuse and violence, T visas, which is based on human trafficking, and U visas, victims of a serious crime. We also, of course, handle removals of condition appeal. And we have recently started taking removal cases with limited exceptions. So if you have an NTA, or you are an NTA, which is a notice to appear in front of an immigration court, or you're facing deportation, definitely feel free to reach out to see if it's something that we can help you with. Okay, so I'm just going to jump right into the questions. Feel free to ask your questions this morning. Someone is saying, what kind of questions can I ask? You can ask questions related to immigration. If I can answer the question, I'll be happy to answer your questions. Good morning, Stacy Siles. Valor says, I want to apply for divorce. We don't handle divorce cases here. Divorce is based on state law. It's not like immigration, which is federal law. With immigration, an immigration lawyer can handle cases in all 50 states, but with divorce, you have to go to a state lawyer, someone in your state, to handle it. Okay, so let's see. A friend has an I-485 interview next week. His daughter filed for him. I-130 has been approved. Is it normal? What should he expect? Yes, an interview is normal. With limited exceptions, you may get an interview bypass. We're seeing interviews bypasses, but very, very limited, not as much as before. But some cases are still getting interview bypassed. What he can expect is questions just to ensure that he meets the admissibility. So him being approved of the I-130 basically means that they do believe that they are parent and child. The I-485 interview is essentially making sure that there is nothing in his own personal I-485 history that makes him ineligible. If you want to understand what that is, basically read the questions under inadmissibility section in I-485. So some of those things can make someone potentially have an issue or not. So it just depends on what it is, but interviews are normal, so that's fine. Okay, so let's see what other questions I have here. How long does it take for you? I'm not sure I understand this question, Tina. don't know if you meant to type that or what you're trying to ask, because you're asking for something about an I-751 duplicate. So I'm not really sure. If you can just re-ask the question, and I will be happy to answer. Dexter says, does your legal assistant team handle your cases fully without any attention from you? Absolutely not. At our firm, we work as a team. The first set of people that our clients work with is our legal assistant, who are your first line of contact and gather all your evidence. Once that's done, we have several rounds of review and revision by paralegals. After paralegals, it goes through our associate attorney, who actually is a former USCIS officer. And after her, then I do my final round of review and edits. The way you want to think about it is that for us as attorneys, when I am looking at an application, whether it's myself or any of my associate attorneys, I'm looking at an application from a strategic standpoint, basically with the eyes of an officer. So, I expect legal assistants to be able to put in a client's date of birth, your street address, and administrative stuff that would go into an application's form. But when I'm looking at it, I'm looking at what is the evidence we're submitting, what here is making my client going to have a problem or be inadmissible. You're saying that you live in New York, but you're submitting bank statements that say Florida. Explain that. Why is this here? Why is that there? So, so my job is to make sure, when I say my job, myself or any other attorney that is hired, or at least in my firm, is to make sure that those files, anything that is a potential issue, or I have a question too, that it must be answered before that file gets signed by me and shipped out. Because if I have a question about it, or it's leading me to believe something and without clarity, then the client needs to clarify it. So that's how we work here. Okay. How long does it take for a whole process of an I-130 for relative in 9J? The answer is very different. It just really depends on who is filing for you. So the timeline is going to be different if it's a U.S. citizen filing for a spouse versus if it's a green card holder filing for a spouse, versus if it's a sibling filing for a spouse, versus if it's a U.S. citizen filing for a child, or a green card holder filing for a stepchild. So the timeline is different. So you have to specifically tell me, this is for Godonu Pat, you have to specifically tell me who it is that's filing, who the petitioner is and the beneficiary, and then I can give you a realistic timeline. I didn't mention my previous marriage in my vow on I-485. Why did you not mention it? So that's a problem. That's misrepresentation. Do not wait for a waiver. You need to be proactive so that you're not misrepresenting yourself. You need to immediately amend your application, and say that you didn't list this, but you need to list it. So misrepresentation happens if you wait till the very end and you don't see it, and they're making a decision without it, or they're the ones asking you, well, why didn't you mention this? So no, you should absolutely not wait for a 601 waiver, because then you're dealing with, do you meet the hardship, to be able to even get that? So you need to immediately correct your application and amend it and submit the divorce decree from your last statement, because quite frankly, they cannot approve your vow if it does appear that you had a previous marriage that they're aware of that you've not mentioned, which USCIS always finds out, and they don't have proof that that marriage has been properly or legally terminated the correct way. So make sure you do that, okay? Denise says, good morning. My beautiful attorney Aisha, thank you for all you do for me and my son. You're the best. I love you so much, not to mention your hardworking and dedicated staff. God bless you all. I thank you. You're so welcome. You're so, so welcome. Good morning. I filed for VAWA since May 2020. Still nothing yet. When do you think is the right time for an approval? I think that that's a really long time, our trading. If you've not heard anything now, I think you're also, let me see if you're the same person that asked. Okay, no, you're a different person. I think you should definitely do a status inquiry now, because if there is something that they need from you to make a decision, then they should be requesting what they need from you. so you're not waiting. But 5 years is a long time, I would say, to still be waiting with nothing. So yeah. What do you do if your EAD card came in your previous name? Not a big deal, because it's going to take you like a long time to get it back. As long as you have some sort of documentation with that EAD, you should be fine, showing that this was your legal name, and maybe you've changed your marital name. So it just depends. Like, have you changed your passport? Have you changed your social security card? Is there a marriage certificate? But as long as you have proof that that's still your name, you should still be okay. Just because EADs, if you want to amend it, you have to return the card, and it can take months to do it. So like, that's not something that like, that's okay. Okay. Someone says my VAWA work permit comes for 5 years. I need that green card without an interview, hopefully. So let me just make a correction here. That is actually not your VAWA work permit. When you file for VAWA and you put in an adjustment of status application, when you get a CO9 work permit, which is a work permit that comes for 5 years, that work permit is because you have a pending case, okay? If you had a VAWA approval, it should never be that long. The work permit you get is going to be a C31, and it's not going to be for 5 years, okay? This is going to be for 2. Now, what's the other question? You said you hope you get your green card without an interview. Hopefully you get it. I'll say right now it's kind of like 50-50, but honestly, even if you get an interview, not a big deal. Just answer the questions and you should be fine. Because, typically when you're scheduled for an I-485 interview after your VAWA case has been approved, you've crossed over the biggest hurdle. So hopefully there's no new stuff or anything that has happened between your application and then, or approval and then, that would disqualify you. Okay. Good morning, Jenna. Okay, let's see. Someone is asking, how long does an I-751 take for a duplicate? I'm sorry, I don't understand that question. Like, a duplicate of what? Like, I don't understand the question you're asking me. I'm so sorry. What is your take on someone applying for N400 on 3-year rule, but I have a previous customary divorce certificate from Nigeria? I don't understand. Are you applying? I'm not understanding you guys' questions today. So are you applying for the N400? The 3-year rule basically means that you either are still married, right? And you live in marital union in the same place with your spouse. That's one way to get it in 3 years. The second way to get naturalization, which is the N400 based on 3 years, is if you are a victim of VAWA, of abuse, whether it's VAWA or an I-751 based on extreme cruelty. But you're here saying that you have a divorce. If you have a divorce, you're not eligible. It will take you 5 years. Am I blurry on Instagram? Because if I'm blurry, I think this computer streaming of my Instagram might not be the best. Can you guys tell me in the comments if my Instagram page is blurry? And if it is, I guess from my next live, I'll just continue with my phone because it looks blurry on my end on Instagram, but Facebook and YouTube look very clear. So I'm not sure. Okay, let's see. What other questions here? I'm married to an American citizen and we have 3 kids. However, my application for change of status, which I'm assuming you mean adjustment of status, was denied due to insufficient funds or assets. What can we do to reverse that? So the question, first of all, would be how long the denial happened. If it was within the last 30 days, you still have time to file an appeal for a motion to reopen as long as you can provide proof that you meet the income requirements. What are some ways that you can meet the financial affidavit requirement? Okay, this is I would say that for a lot of people who try to do this on their own, or don't want to seek help, this is the number one reason for their denial. They don't understand the I-864 or how the I-864 works, and they usually end up getting denied and come to us in a panic and a frenzy to reopen their cases. So this is what is required to be able to get your I-864 to go through, because it is a requirement. Your I-864 is your financial affidavit of support. The petitioner, first of all, must file taxes. That's number one. If they don't have taxes, they have to have proof that they were exempt from filing taxes because either they didn't make the income, they were not working, or whatever, right? So let's start with that. So if they file taxes, the next thing that's going to happen is USCIS is going to look at their family size. The income requirement is going to be different for everyone. So now, Ruka, let's use you for example, and let's just assume that all your children are under 18 years old. So for your spouse to file for you, they're going to count your spouse, they're going to count all three of your children, and they're going to count you. So you would be considered a family of five. So let me just tell you, let me just pull up the chart, and I'm going to tell you what, as a family of five, you have to make to be able to file, and I'll tell you how to overcome it. So as a family of five, the exact amount that you need to make is $47,062. You need to make at least $1 more over that to be in a secure place. Not you, your petitioner, the U.S. citizen. And I'll tell you how they determine income in a second. So this is considered 125% of the household poverty guidelines in the United States. So again, the income requirement changes depending on how many people is being counted in your family, okay? So let's say that this is the income, for instance, and your spouse makes $40,000. So basically, let's just round it up so that I can make it easy. Let's just say, like, whenever people ask me, I always give them the whole number. So even though I said it's $47,062, I always say to people, the best or the safest place to be would be anything over 48,000. So what is the first thing that USCIS is going to look at? The first thing they're going to look at are your taxes. And the specific number they're going to be looking at on your taxes is what we call your adjusted gross income, which is your AGI. Okay? That's it. The second thing is, because a lot of times people look at the regular income, which might be different from the adjusted gross income, and say, oh yeah, I met the requirement. And sometimes that can throw you off. Let me give you an example of how it can throw you off. Sometimes you might be a business owner, and sometimes business owners can take deductions. So let's say a business owner made like $100,000, and we're still using this exact same family size of Ruka. And maybe they did deduction here, took this business expense here, this deduction. So even though they know that they made $100,000, by the time they adjust their gross income to include all those tax deductibles, it shows that they made $40,000. So that number in their income is not the number that USCIS will use. They will now be using the $40,000 amount. Okay, so now $40,000 is not enough. So what can you do to get the extra $8,000 to get over the $48,000 hump? The first thing you're going to do is you're going to, first of all, see, the easiest way would first be to see, do you have a U.S. citizen, friend, family, relative who can meet the income requirement, right? Remember, their own income requirement is not necessarily going to be for a family of a family of five. Their income will be based on how many people are in their family, or if they're single. For example, if they're single, all they would have to meet is $27,000. I'm rounding up the number. If they have a spouse, all they need to meet is $34,000. Do you understand? I hope, because I-864 is a bit complicated, but I'm trying to break it down, because I know this is like the number one area that I see a lot of people get denied. And it's very sad to be denied for that and be placed in deportation for something as silly as that, when you could have just hired a lawyer and they would have done the math properly for you. But let's just say you're trying to do it yourself. This is how you do it. So if, let's say, you cannot find a US citizen or a 10-year green card holder who can meet the income, the next thing we're going to look at is assets that you and your wife might have. So an asset is anything that you have that is convertible to cash within a year. So what are some examples of that? Your bank account, your checking account, your savings account, your 401k, your retirement, your home. So if you have a mortgage, I'll get into mortgage in a second. If you have a car that's paid off or whatever. So remember that the amount that you have to get over 48 to get over the hump is 8,000, because remember, this example I'm using, the person makes 40,000 and they need 48,000. When you are using assets, it changes from that 8,000. Your assets must be the difference times 3. I'm getting into math here, so hopefully you guys are still following me. Are you guys still following me? So it's the difference times 3 here. Okay, so basically it's going to be 8,000 times 3. What is 8,000 times 3? Let me see if my math is correct. It should be 24,000. So basically you have to have assets worth 24,000 for you to submit those assets. Okay, so what does that look like? If you are going to submit your house, like let's say you have a house and the house has a mortgage, right? One, USCIS is going to want to see a mortgage statement to know how much you have paid down and how much you have that you owe, right, remaining on your mortgage. So let's say you have, let's say your mortgage is like $400,000. In fact, let's go lower. Let's say it's like $200,000, and you've only paid, you put like a 20% down, which means it's $180,000 or something like that, and you just purchased the house. One of the things that you can do is you can look at like your county tax assessor, right, and see what are they assessing the appraisal value, because a lot of people will not generally have time. Like in your case, if you're filing an appeal, you don't have enough time, right, to go get an appraiser or whatever it is, because you have 30 days, and depending on where you are in those 30 days, you can go to go online and get your property, and it will tell you every year what the tax is assessed for, which tells you the county or the city's appraised value of the case. So we usually will add that, because there's Zillow and Realtor.com and all the rest of them, but they don't really look at that as the true value. So as long as you can show that, let's say, you've paid down your house and maybe what's left of your mortgage is $160,000. So even if you sold the house today, at minimum, you're going to be making $40,000, however you distribute that, whether it's to a realtor or whatever. But they basically would look at that, and then you can then add that as your asset, which would get you over the hump. Because with the assets, remember I said the hump would be 24,000. So you just need to get over 24,000. Same thing with the car. If you have a car and you have the car paid off, the car should at least be worth $24,000. Same thing with your 401k, your checking account, your savings account. If you're using your bank statement account, they're not just going to want to see 1 month's payment. They're going to 1 month statement. They're going to want to see like 12 months. Just to kind of see that you coast around there. So those are some ways that you can overcome it. And I hope, Ruka, one of these options are something that maybe you have available, so that you can, try and, file an appeal if you're still within your appeal window. I'm in an I-751 petition limbo. How can I speak to you, ASAP? Do you have a chance for a consultation today? I definitely do not. But you can call the office. Our number is right here, and you can get scheduled with either myself or any of my associates, whoever has the most early consultation. Again, we work as a team. Like, sometimes we're like, oh, I wanted to speak to you. It really doesn't matter who you speak to. There's no case that I'm not aware of here, or I don't see the summary of at the end of the day. So it doesn't really matter which one of our attorneys you speak to, because, we go for all the cases. Okay. Okay. Kevin says, good morning. I went to the USCIS website to check on my VAWA case that's been going on for 3 years, and USCIS said they've sent out a letter giving instructions on how they will. You didn't finish your question, but depending on what it is possible that you received a NOID. That's usually what that means. I don't want to jinx it for you, but it's likely that you have a NOID. A NOID is a notice of intent to deny. Basically, they're telling you what they're trying to do, that they're intending to deny the case, and then they're going to give you 30 days to overcome the issue that you're having. So hopefully that's not what it is, but that's usually the language that's used for a NOID. Okay. Asking for a friend, is it safe to travel with a travel document without knowing your friend's immigration history? I can't answer the question. Do you handle non-marriage immigration cases? What case type? It depends. What is it? We handle family-based cases. We handle siblings, children, abuse cases, T for trafficking, and U visas. So what is it? What kind of case are you referring to? How long does it take for a citizen daughter to complete? She's from Caribbean. So I'm assuming you're asking how long does it take for a U.S. citizen to file for a daughter, for a mother? Is that what you're asking? If that's the question, the first thing is that the U.S. citizen must be 21 years or over. They must show that they meet the income requirement. And a good rule of thumb is consular processing can take anywhere from 2 years to 3 years, depending on the country it is. This is how I always tell people to plan it out so that they can kind of have an idea. And when you file the standalone I-130 based on a U.S. I'm only speaking right now for U.S. citizens, children that are over 21 filing for your parents, you're going to see an average of somewhere between 6 to 13 months for the I-130 decision to be made. Once the I-130 decision is made, then it moves over to the National Visa Center. And at the National Visa Center, that's when, the application is done for the mother who's the beneficiary. Her own application is done at that time, her own police clearance, all of the information that's needed from her. And then that's also when the tax transcript and the financial affidavit of the U.S. citizen is also needed. Once that's uploaded, USCIS will review it and either documentary qualified or say they need more. And on average, that can take anywhere from 1 to 3 months. And then once that's done and you're documentary qualified, they place you in queue for an interview. So now this is where the time can vary depending on what country you're from. So depending on some countries, they can place you in queue and 4 months later, they will schedule you for an interview. Some other countries are very busy. It will take a year. Some other countries, it will take 13 months. So that's why I always say on average, you want to plan for anywhere from 18 months to 30 months, just to cover your bases for consular processing. Okay. Okay. Can I travel within the U.S. with my EAD and new driver's license? I have a pending VAWA. I've received 2 prima facie determination letters. You should be able to travel. Just make sure that if your new driver's license is not real ID, you want to make sure that you take an unexpired passport with you. Okay. My friend is getting married in Nigeria, and she's worried about traveling. She got her green card through VAWA. Well, if she doesn't have a criminal record, and she's not done anything that will, cause her to be arrested, or that there's a warrant out or anything like that for her arrest, she is a green card holder. Green card holders are allowed to travel. Like every day, my clients return from or my past clients or present clients who are doing 751s return from their trip and tell me, I came back with no issues. Personally, we've been very lucky. We've never had anyone with any issues, but also most of our clients follow our advice, because someone might send an email saying, attorney, can I travel? And I say, no, the stage you are in your case, I'm not comfortable with you making an international trip, and others, I say, you're fine. You're fine to go take all this. There's always a risk, but we've not had any issues with ours. But, travel is really a deeply personal question, because for someone to truly advise, like a lawyer to truly advise someone, they need to know their immigration history to be able to tell them, but typically 10-year green card holders can travel, as long as right now you don't have any criminal records. um, you know, I received my green card in April of 2021. Am I eligible to apply for naturalization? 22, 23, 24, 25, April, May, June, July, August, September. Not yet. You have a few months. So for you, because I'm assuming that you're asking because you're doing it based on the 5-year requirement. If you're doing it based on the 5-year requirement, then you need to wait till 4 years and 9 months is what you count to the date. Esther, as a green card holder, can one be outside the US for more than 6 months? I don't recommend it. Can you? Sure, if you have a legitimate reason, and you are making sure that you're still keeping your ties here in the United States, as you should keep your ties. Like, you don't want it to seem like you're abandoning, the US to go live somewhere else, and you're just coming back here like to fulfill all righteousness. So it just depends on the situation, like, we've had clients who, we had a client who traveled like for her husband's funeral. Like, her husband was sick, and she ended up being out of the country for like 2 years. Do not do this. You should absolutely not do this. But I'm just using this as an example. And because with her culture, she had to, spend some time there, mourn, and just, eventually came back. They let her back into the country. And I remember when we went for her naturalization, the officer said, well, you've abandoned your citizenship. I mean, your green card, because you left for more than a year. I said, officer, you can't do that, because as long as Customs and Border allowed her into the country, she basically did not abandon her green card. So if we backdated and counted, as long as we can show she's been here for 2.5 years out of those 5 years, officer, you should approve her, and, she was approved. Now, that is not something that I do advise. But in that case, she had every tie, to the US. All her children were here. She was in her 80s. She had nothing back there. Like, so, her child claimed her as a dependent. So you just basically want to cover your bases, because sometimes if you go for a really long time, especially if you go for more than a year, USCIS, Customs and Border can make you sign a form at the airport saying that you've abandoned your application. A lot of times what they'll do is they'll say, sign this form and abandon your green card, and we'll let you in on a tourist visa. But for a lot of people, if they don't have anybody else to refile for them, they'll be screwed. Then it means they're done. Like, we've had clients who signed that and came to us after they signed that. But luckily for those people, they still had family members who could file for them. So that's how they were able to get it. So try not to if you don't have to. But if you have to, just document it so that you can explain that. Or the other thing is, to avoid all of this, if you know that you need to be outside of the country for more than a year and you're a green card holder, it is best that you get what we call a permission to re-enter. Like, basically, you want to apply for it before you leave the country. You can always schedule for you to pick up that permit, that travel permit in your the U.S. Embassy in the country that you're going to. But it's best that it's applied for here in the U.S. for it to be approved. That way you don't feel. Then that way it's clear that you didn't abandon it. So that's something that you can do. Okay. Okay. Let's see. I filed my vow in October of 2023. I got my travel and work permit with 2 prima facies. How much longer till the vow is approved followed by my green card? I can't tell you the answer because I don't know. But that being said, we're definitely seeing like a lot of both 2022 and 2023 cases coming through right now, either whether it's an approval or whether they request an additional evidence. Once they request an additional evidence, it means that they've started to review your application. So, you are in the window that anything could come between now and end of next year, because really most people will get it at the 3-year mark. I see someone else asking about 2.7 years. So you not getting your prima facie doesn't mean anything. It's just that USCIS is late sometimes in giving their prima facie, but you're in the window basically for them to make a decision or request additional evidence from you. Aminette Williams is asking the same question about traveling with driver's license. I answered this earlier, so you can rewatch the video to see what I said. I wanted to know if a green card holder can apply for his girlfriend and how long it will take for the girlfriend to reach the United States. No, you cannot apply for your girlfriend as a green card holder. If you were trying to apply for your girlfriend as like maybe you're proposing to her as your fiance, you need to be a U.S. citizen. The only people that can file for a K-1 fiance visa are U.S. citizens. A green card holder is not eligible to file for a fiance. The only category of people that green card holders can file for are spouses, your husband or your wife, or your child, or your son and daughter over 21. But your son and daughter over 21 cannot be married. Okay. Okay. What can someone do if his interview appointment for naturalization has been canceled since April and never had any other appointment or hasn't heard anything since then? You definitely want to reach out to USCIS and check. I would say, first of all, check what the processing time for your city is, and then reach out to USCIS, and hopefully that will get you or the ball rolling. Otherwise, I would say seek congressional assistance. Congressional assistance honestly is touch and go, to be honest. Like personally, I preferred using the ombudsman, but USCIS with this new administration removed the ombudsman office. Lawsuit was filed. They brought back the ombudsman office, but there's like one person in the ombudsman office when there are like hundreds and thousands of people filing. So I don't really know that it is effective, or I haven't seen any update that they can do anything, but it would have been the best option, I would have said. So try your congressman or congresswoman again. Congressman and congresswoman also depends on their stance on immigration. If you have people that are very anti-immigration, it might be harder for them to reach out or advocate for you. So it just really depends on who your, congressperson is. Okay. So it's saying I'm blurry. Okay. So I definitely will not be using my computer for my Instagram live since it's so blurry. Good morning and God bless you. Thank you for everything you do. I want to know, because I have not gotten anything from them since 2022. I got married, but my green card has not been given to me yet. So you're saying that, did you apply for like a marriage-based green card? If you apply for a marriage-based green card in 2022, this is a really long time. I would be curious to know your immigration history. Did you have a Stokes interview? Were there any issues with your interview? Have you been scheduled for an interview? Did you have a previous marriage? There'll be many things that I would want to know. Y'all, I am so sleepy today. Like I barely got any sleep. My daughter has a physics test today. I know nothing about physics, but I was helping her study for physics and, making quizzes and questions for her. So we're up very late. Okay. Someone is asking about an affidavit of support again. I just answered the question. That's literally what I talked for about 10 minutes. So when I get off this live, replay the first 10 minutes, and I talked about all things I-864. So hopefully you can find your answer there. Okay, let's see what else. Asking for a friend. She filed for VAWA. And on September 13, it made 3 years, but nothing yet apart from a prima facie. Is it normal? Right now, yeah, it's normal. So hopefully, she'll hear something very soon. If not, she can also make an inquiry just to see if, that will get them moving the needle. If they need something from her, they should let them know, Keisha Edwards says, "Good morning. Can I make arrangements with you because I'm traveling internationally in December in case anything happened at the airport? Need to know who you are, what your case is. I don't know if you're one of our clients or not, but if you're a client, you probably know I don't know, if you are or not, but with our clients, if you're traveling, you definitely would want to reach out to us, give us the dates, and we need to confirm that you can travel internationally first before you can go anywhere. But otherwise, we hope nothing happens. I think I've told you guys the story of the two craziest things that ever happened to my clients that traveled international. I think, and knock on wood, hopefully that's as bad as it will get. Well, one did not communicate with us and left the country, and their case got denied while they were outside the country. Luckily, the denial was in error. We had reached out to this congressman. The ombudsman was still opened. I was like, "Get your behind back in America this minute. Go to the airport as I'm speaking to you and get back in here." But luckily, they reopened the case. He got back in within like weeks. Got back in and got his green card. The other crazy case was client had two work permits. Two work permits. One was for VAWA approval. One was a combo card with their travel permit. They left their travel permit, the EAD with their travel permit here in America and left the country. So they were connecting through another country. So they let them travel to the other country with their country of origin's passport. When they got there, they said, "You can't come to America. You don't have a travel permit to come to America." Client calls me. This was on New Year's Eve, like SOS, SOS, SOS. I am stuck in this country. They're not letting me back into the US. And I was like, why? Why wouldn't they let you back? You have a travel permit. She's like, they said, "I don't have a travel permit." And I said, send me a WhatsApp, send me a picture of your travel permit, because that doesn't make sense. And then client sends me their travel permit, and this travel permit that she traveled with was a VAWA work permit, which is not a combination card ever. So it turns out that her travel permit that was in the combo card was here in America. So luckily she had a relative get it and DHL it to her, and then she was able to fly back in. So I would say those are the two craziest cases we've had. But again, honestly, I can't stress it enough. Whether you're a client of my firm or you're a client of another lawyer's firm, it's always a good idea to reach out to your lawyer before you travel. Give them the dates you want to travel. Let them see the stage you are in your case, and let them make some suggestions based on that. Clients do get upset when I tell them, I don't recommend traveling now. They're like, "Oh my gosh, why can't I travel? I have a travel permit, blah, 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 blah." But guys, let me just remind you, what is my job? My job is to keep you in the United States legally, right? Like, I don't want anything to happen to my clients. I don't want my clients to lose their chances of getting a green card or not to be able to enter the country. It's just like a parent, it's like your child saying, "Why can't I go out with my friends, at 9 p.m. or 10 p.m. and like they're a teenager?" And you're like, because, a lot of bad things happen, So it's the same way, like when I'm given that advice, it's not because I don't want you to travel and enjoy yourself, but it's because, my job is to protect you, right, from deportation or from being stuck on the outside. So, again, have I advised people saying, it's kind of risky, I prefer that you don't. And they're like, I will take the risk and they're fine. But, it's important for me to still lay out the risk. And then once I lay out the risk, you can then decide, is it worth taking the risk or not? My husband filed the petition for me and my son. My income was used on the financial affidavit for a 3-person household. Sometimes your income is not eligible depending on the kind of job you have. If you're working under the table, if you don't have, it depends on what your own status is, so you have to have legal status of some sort. That you're working under that legal status, and that job is kind of like protected based on your legal status. For them to accept your income. Okay. Carlene says, excellent law firm customer service. Oh, thank you so much. Thank you. Thank you. Carl says, what is the difference between a notice to appeal and a notice to appear? That's a really good question. A notice to appeal means that USCIS has made a decision of denial on your case. It means they've denied your case, and now you are filing an appeal. You're appealing the denial of your case. A notice to appear means it's a notice to come to immigration court and appear in front of an immigration judge for deportation or to plead why you should not be deported. So hopefully that makes it a little clearer to you. Okay. Can I file for naturalization while my removal of condition is pending? The answer is that it depends. It depends because, it just really depends on, wait, the question just skips. Hold on, let me scroll back up. Oh, it seems like on this computer, my questions disappear. Oh no. Can you please ask your question again? I don't even know where that question is right now. Let me scroll back up and see if I can find it or refresh it. Yeah, that question just disappeared. What was this person asking me now? Let me just see if I can find it. Yeah, I can find the question again. Oh yeah, I found it. So you were asking about naturalization. So the answer of whether you can file for naturalization if your removal of condition is pending is, first of all, we need to make sure that you're eligible for naturalization, because a lot of times people think that, okay, I've hit the 3-year mark, or I've hit the 5-year mark, I can apply for naturalization. There are a lot of things that we still need to go through to make sure you're eligible. First of all, we have to make sure not only that you're filing taxes, we need to make sure that you're filing taxes in the right category. Because, if you're trying to file for naturalization for 3 years, saying that you're married and you have a pending I-751, you should not be filing the head of household, right? You should not be filing single. So all of those things can disqualify you. We need to look at your criminal history. We need to look at whether, if you're male, how old were you when you got the green card? Did you register for selective service? We need to look at taxes. Have you paid all your taxes, or are you on a payment plan, or have you filed taxes? If you're on a payment plan, that's fine, as long as you stay on the payment plan and make the payments that you need to make. Do you have children that don't live with you that are under 18? And what proof or evidence do you have that you support those children? Do you have infidelity, or do you have a history of infidelity? Because when it comes to good moral character for citizenship, that's some of the things they look at. Now with the new rules, they're also looking at what are your contributions to society? Like, what are you doing for society, in your family, in your workplace, with your neighbors, or any of all those things. So, we have to look at those things to determine if you qualify. And then finally, do you have a strong removal of condition case? When clients' cases are not so strong, or they're really, really lacking in evidence, I don't necessarily push for them. In those cases, I believe using the gift of time is the best thing, because the gift of time means that you're not going to speed up your decision, and you can continue with your green card or your green card extension until however long it takes. But the thing is, when you have a removal of condition and you file an N-400, you speed up time, because N-400 has to be made. N-400 decision has to be made within a certain timeline. And if they do deny your 751, no ifs, buts about it, you're going to be placed in deportation or removal proceedings. So Again, the answer really depends. Someone is saying, good morning. Is a fiancé visa guaranteed? Absolutely not. A fiancé visa is not guaranteed, nor is any application guaranteed. You know, like there are many people that have been married for years or even have children that end up getting denied because of, for whatever reason or whatever they presented. So there's no application that is guaranteed. You just want to do your best to put together a really solid application and be able to handle or answer every discrepancy either prior to submission or if you're scheduled for an interview. And that's why, if you remember what I said earlier in a consult, what my role as an attorney is, I have legal assistants to put in administrative tasks like fill out the forms, put their date of birth in there, put your birthday. But I have to look at it from a strategic standpoint, like what is wrong with this application? What is going to cause an issue in this application? How can we address it? Can you explain to me why, you didn't list your child in your previous application? Are we going to need a waiver here? Can you explain to me what this picture is? You have this pictures. I always use this example all the time. Like, people, you ask them for pictures and then they give you pictures of their wedding day where they look crazy, for lack of a better word. And I'm just like, if you can't take your marriage seriously to look decent or brush your hair on your court wedding day or whatever, USCIS automatically doesn't think this is a serious marriage. So, the old adage is true where, they judge a book by its cover. Your appearance matters. To me, if you have sloppy pictures like that of your wedding, like meaning like you had like a court wedding, you look crazy, you didn't brush your hair, you're wearing all kinds of whatever, to me, it's best from a strategic standpoint not to submit those pictures because you don't want them to use those pictures to judge you or to make to determine who you are. Okay. So yeah. So let's see. Let's see. Okay, so Sakir says, hi Aisha, my vow was approved on I-485 as well. So I'm waiting on my green card. I just wanted to say thank you for your help. You're amazing, the best attorney. Oh my gosh, yay. Congratulations. I'm so happy for you. Great. I already answered the question on naturalization. I don't know if you heard me, but it's on there. I have my interview coming up in 2 weeks. You guys, like these questions keep disappearing. I have my interview. See, as I read it, the questions disappear and I've lost that question. Somebody was asking something about Philadelphia and the question has disappeared. Like for those of you that say, okay, I found it now. I have my interview coming up in 2 weeks and what to expect scares me, VAWA applicant. So can you clarify what interview do you have? What is on your interview notice? Is it an I-485 interview or is it an I-360 interview? Because it is very, very different. So once you tell me that, I can tell you. Okay. All right, guys, let's see. I will take 2 more questions and then I got to jump up. I've actually been here for almost an hour. Yeah, Sonia Lawyer says document your life together, get involved in your community, they're checking social media. Absolutely. Someone is saying, I got shot driving for Uber. Oh my goodness. Can I file for VAWA? How long does it take to get approved? I mean, not VAWA, U visa. Well, being shot is a victim of a serious crime. U visas take a very long time to get approved, very long time, because it's based on visa availability. Sometimes it could be 5 to 7 years. That being said, if you have a bona fide case, usually you can get your work permit between a year to 18 months from application. So at least you'll have a work permit while you're waiting for your visas to be available to you. And sorry about that. And I'm glad that you're alive and well to be able to, come on here and chat. Okay, let me take one more question. I don't know if you guys are writing them in duplicates or, what's happening. Like I just keep seeing the same questions over and over and then the new one will disappear. How long does an I-130? B Dammy, are you like pacing your question like every 2 seconds, or is my system glitching? You know, I'm gonna answer your question, but it's literally distorting all the other questions. So stop doing that if you're doing that. Good morning. How long does an I-130 take to get approved? Mine has been 345 days. Do we wait for an approval before we move forward with a green card? Well, I don't know what kind of case you have. Like, where's the beneficiary? So, you know, who's filing for you? So the answer depends. It depends on if this is a marriage-based case. Is it an adjustment of status case? Is it a consular case? So you don't, but that's actually obnoxious. You should not be posting and, you know, not allowing others' questions to be answered. You know, like I try to move in turn, but when you keep doing that, I can see other people's questions. That being said, if you want to schedule a consult, our number is there, 407-995-6567, or you can call 678, let me see what the number is, 678-325-1037, or you can send a WhatsApp to 404-333-8751. All right, guys, I hope you have a wonderful day, and I will chat with you all later. Bye.